The next case set for argument this morning is State of Ohio versus Darren Townsend. It's case number 29221. Both parties are represented by counsel. Each of you will have 15 minutes to present your argument. The appellant may reserve up to 5 minutes for rebuttal. Let me know if you're going to reserve time and I'll keep track of that. It's also posted on the television. The arguments are recorded and posted on the 9th District Court of Appeals website, so we ask that you stay by the podium and keep your voice up during your argument. We've read the briefs and we are prepared to proceed if you are.
I would like to reserve 5 minutes for rebuttal.
All right, thank you.
Good morning, Your Honors. May it please the court. Today we are here challenging the validity of a plea in this case for Mr. Townsend, specifically whether or not Criminal Rule 11 was strictly complied with as it relates to your constitutional right to a jury trial and whether or not that was actually validly waived. When we're looking at the Criminal Rule 11, some of the things that there's a laundry list of things that the court is required to do in terms of making sure that the defendant is aware of what is happening. And specifically, the court is required to address the defendant personally and inform them of the constitutional right to a jury trial. In this case, it's a little bit of a different scenario since there was actually a jury trial that was taking place. And then in the midst of that trial, there was a decision to do a plea. When we're looking at what the court is required to do, however, the court has to actually inform the defendant of that right, and I think that's a little bit absent in this case. Now, when we're looking at the transcript on page 819, the court does say you're giving up your right to have a trial here today. Do you understand that? I don't believe that that's sufficient for Criminal Rule 11 strict compliance, and I think that's mainly because the actual right to the jury trial is not expressly stated there. And I think it's important when we're looking at Criminal Rule 11, it doesn't say that the court has to notify a defendant that he's waiving his right to a trial. It specifically says jury trial. And that's where I take issue with what happened in this plea colloquy in this case. Now, I do recognize that a verbatim recitation is not required by case law. However, I think it's important, since the fact that he actually was exercising that constitutional right, that it would have been important for the judge to actually make a specific reference to that jury trial right. Now, there's a similar case out of the 3rd District. It's not within my brief, but I'll give you a case site. It's State v. Howard, 2017, Ohio 8020. That case was another plea that happened in the midst of a trial. In that case, the Court of Appeals in the 3rd District essentially said that the statement by the court was enough to warrant essentially the waiver, but the court in that case told the defendant that in entering the plea, the balance of your trial will not go forward. And I think that's a little bit distinguishable from our case here. Had the judge said to the defendant in this case, you're not going to continue to proceed with this trial, you're waiving that right, I think it would have been unambiguous and clear that there was an actual waiver of his right to a trial. So I think that's a little bit of what's going on here. And again, it doesn't have to be verbatim, but it has to be reasonably intelligible to the defendant. And I think that when we're looking at this as a bigger picture, the fact that Mr. Townsend actually filed to withdraw his plea after the fact demonstrates that there was something else going on at the time when he actually entered the plea. So, and that segues into my second argument that's within the brief, whether or not the court made an error when they essentially denied the motion to withdraw the plea without having a hearing. Now, that Rule 32.1 does govern your motion, so withdraw your guilty pleas. That's the plea after sentence. You have to be able to prove that there's some form of manifest injustice. And there's a case out of the 9th, that's the Kosovage case, 1995, Ohio App Lexus 2830, cited in my brief, where a hearing isn't proper if 2 things are found: that 1, the movement isn't entitled to relief, and 2, they failed to submit evidentiary documents that demonstrate that manifest injustice. In this case, originally, the court didn't make any sort of ruling on the motion, and it was kind of just in limbo. So motions after the fact are deemed denied, therefore it was denied without a hearing. This court remanded it back to the trial court for a ruling on that motion, and it was again denied without a hearing. From our standpoint, when looking at the record, the appellant in this case actually put forth some information for the court's consideration that I think was enough to warrant the hearing. He essentially attached something that indicated that he felt coerced into actually entering the plea at the time that he entered it, and that he was doing it out of fear for threats that were happening to his family. Had the court actually brought him into court and had a conversation about what was actually going on, I think we would have had a better understanding of what was going on in his mind at the time of the hearing, the plea hearing, and whether or not the plea should have been withdrawn at that point.
Did the court ask him if he was being forced or coerced to enter a plea at the time he entered his plea?
There was a conversation during the colloquy where he was asked the question of whether or not he was forced or threatened, and I don't believe that he personally was being threatened. I think it was his family, and that's why I think that the court should have had a hearing on that request to withdraw his plea. Even when it was remanded back, the court just looked at the record and said, no, I'm not. They essentially denied it. But I think it would have been important at the time, especially with the information that was provided to the court in that written request, where he had indicated that he was coerced and that there was some threats to his family. I think that should have been addressed more, not simply the question to him of whether or not he was threatened or promised anything in exchange for the plea where he said no, but I think that turns to whether or not, I think there should have been some conversation about that. And ultimately, the court could have still denied the request, but the fact of the matter is, I do believe it was warranting a hearing on the motion to withdraw his plea, and it was improper for the court to actually not have that
I guess
conversation.
I'm still not understanding how that wasn't a coercion or threat to him, because the whole point is he's saying I had to enter this plea to protect my family.
Well, and I think, I agree that he very well could have said he felt coerced because of the family threat, but I think the form of the question was he being threatened? And I actually have a copy of the transcript.
That's okay, I understand.
But I think it would be different had the court asked the question, and that's why I'm saying I think a hearing would have been appropriate on the actual motion to withdraw his plea when he presented to the court, hey, there were threats to my family, and that's why I entered the plea to begin with. And that's why I think a hearing would have been warranted, because then the court would have been able to have that one-on-one conversation with Mr. Townsend to distinguish between, okay, so I previously asked you if there was any threats or coercion in this case. You said no. What are you referring to here? And I think that would have been a conversation where he could have actually clarified and cleared up the fact that it wasn't a threat to him personally, which is the form of the question when you're during that colloquy, versus what the actual threat was. I think that would have been appropriate for the court to actually have that conversation. And again, had that conversation took place, the court then would have additional information to consider whether or not actually withdrawing the plea was warranted under the circumstances. But the fact of the matter is the court simply denied the motion without a hearing, and that's what we're arguing is improper in this case. So essentially, if the court finds that there wasn't a valid waiver of his constitutional right to a jury trial, we would be asking the court to remand this case back to the trial court and essentially to start over from square one without the guilty pleas. In the event that this court is not persuaded that his rights weren't violated during that colloquy, we would still ask the court to remand to the trial court so that a hearing can be held on his motion to withdraw his plea.
All right, thank you. You'll have a full 5 minutes for rebuttal.
May it please the court, Heaven D. Martino Guest on behalf of the state of Ohio, the appellee in this case, we are asking that this court affirm the decision of the trial court. With regard to the Criminal Rule 11 C2C notification that the defendant has the right to a jury trial, the state agrees that it is reviewed for strict compliance, and the state also agrees that a word-for-word recitation is not required, nor are there any magic words that are required. In fact, the underlying purpose is to convey to the defendant certain information so the defendant can make a voluntary and intelligent decision. So here, the underlying purpose was to make sure that Mr. Townsend knew that he was waiving his right to a jury trial. And this came up on the third day of trial, after the state had presented its entire case in chief. All the exhibits had been introduced, the defendant had called a witness of their own. The only thing left was going to be jury instructions as well as closing argument. So in that backdrop, the court said, now you are giving up your right to have a jury trial here today. And the state would argue that in that backdrop, when the court says you're giving up your right to have a trial here today, it's clear to everyone that the court is referring to the jury trial that they are here conducting for the last 3 days. Just like the third district case where the court had mentioned that it was a trial, not a jury trial, but it had been in the process of the trial. The fact that that case had not proceeded along as far as this one had, and then the court made that reference to the balance of the trial. The balance of the trial is not going to go forward. It's the same purpose. It's the underlying purpose that's being met. We don't have to have the magic words, and we don't have to have the recitation word for word with Criminal Rule 11. There's no other case cited to you by the defense, and no other case that I could find where at this point in the trial, when the court refers to you're giving up your right to a trial here today, which was clearly a jury trial, that there's an argument that can be made, a colorful argument that can be made, that the defendant did not know that what he was giving up was a right to a jury trial. It's clear that that's the type of trial that they were in, and that's where they were at in the process. They were very far along in the trial. So the state would argue that based on the underlying purpose for the court's notification to the defendant, that in this case, Mr. Townsend did in fact know that he was giving up the right to a jury trial. And the state disagrees that by filing a motion to withdraw his plea, that he was raising an argument based on lack of knowledge about a jury trial. His motion to withdraw his plea was based on his allegations that there had been a threat to his family, and that because he was afraid for his family, that was why he wanted to withdraw his plea. It had nothing to do with him believing he did not have a jury trial. With regard to that second assignment error, the state would argue that it's moot at this point. When the brief was filed, the remand had not yet occurred. So the argument was based on the premise that the trial court had denied the motion because it hadn't been ruled on, and furthermore, that by denying it without hearing, there was an issue. So now that it's been remanded, and there's a journal entry that is not been made part of this record that was issued by the trial court on May 13, 2019, counsel would like this court to take her argument that she thinks that certain things should have occurred or should not have occurred when there's no record before this court, or what actually did occur, or what was in the affidavit. And there was an affidavit that was filed by Townsend where he talked about what his basis was for withdrawing the plea, and the trial court found that the affidavit statements were directly contradicted by the record before that court, which establishes that he received no threats or pressure to enter his guilty pleas, and therefore he was not under any type of an influence when he entered the plea. So to ask this court to make findings when those things were not before the record, I don't think it's procedurally proper. I think at some point, if counsel wanted to proceed on an argument relating to the motion to withdraw, then they should have asked that this court allow for further briefing, or that the trial court record below be brought up, but it hasn't been. So what's before this court is what was filed in the trial court below at the time the brief was filed, where there was no decision issued. So based on just the procedural posture that this court does have before it, which is that it was remanded for a decision, this court can find that that second assignment error is moot, and that the court does not have the information before it that it needs to issue a decision, which is the appellant's obligation under the rules of appellate procedure, so that the court can make an informed decision with regard to the merits of that. If there are no...
Give me that time again, the motion
The
withdrawal was filed
The motion to
after
withdraw.
the notice of appeal.
So the motion to withdraw was filed in the trial court, and it was never ruled on. Then Mr. Townsend appealed, and he raised this issue about the right to a jury trial notification, and he also argued that the trial court had failed to rule on his motion to withdraw his plea. Then they asked this court for a limited remand, and this court agreed to it. So while this case has been pending, it was remanded back to the trial court for that decision. Now counsel is asking you to make decisions based on her representation of what the record is below.
Gotcha.
That is not for the court.
And if there are no further questions, I would rest on my brief. Thank you.
All right, thank you. Counsel, you'll have 5 minutes for rebuttal.
Thank you. I want to just segue a little bit off of what the state has said regarding assignment of error number 2. In our initial brief, we didn't argue the fact that the motion was essentially denied. And I'm a little bit confused with what the state is suggesting, because that's not the premise of the actual motion. So the assignment of error number 2, the assignment of error in our brief was that the court denied it without a hearing. That's still the argument today. The case that I cited within the second assignment of error was that XREL v. COS Marshall, 81 Ohio State 3D 467, where motions that are pending upon the disposition of a case are deemed denied.
Counsel, was the motion for 60B pending upon the disposition of this case, though?
The motion was filed after he was sentenced, but before there was an appellate case pending.
So does that case law about motions not being ruled upon before the disposition apply to 60B motion?
I believe it does apply. The case law says that pending motions upon disposition are deemed denied. The case was disposed of, there was a pending motion, it wasn't ruled upon.
What was pending when it was?
He filed the motion to withdraw his plea pro se after he was sentenced. So the case was disposed of, but there was a pending matter still before the court. That's his request to withdraw his plea. When it's not ruled upon, it's deemed denied. My argument in the brief is because it's deemed denied, there was no hearing, therefore his rights are violated because the motion was denied without a hearing. That's still the same argument that we're making here today, is that there was no hearing on the motion, it's still denied without a hearing. Whether it be before, where it's deemed denied when there is no hearing, deemed denied by the court by not ruling on it, or after the fact when the court actually did rule on the motion without a hearing. Either way, there was no hearing on the motion, and I believe a hearing on the motion would have been appropriate under the circumstances. When it was presented to the court with a pro se motion by the appellant to withdraw his plea, information was provided to the court, which would have needed some additional questions and background, and I think a hearing should have happened at that point. So the argument is whether or not it was just left and forgotten about and deemed denied, there still was no hearing. And that's why our argument, I think, stands up no matter what, is that there wasn't a hearing to make a determination of whether or not the plea should have been withdrawn. And that's what I'm arguing is required. The court should have held a hearing to determine whether or not there was a valid basis to withdraw his plea based on the information that the court was provided with at the time.
Okay, I just want to make sure I understand. So the motion to withdraw the plea was after sentence?
That's correct.
Okay, so the case was it before the journalization of the sentence or after the journalization of the
I
sentence?
believe it was after the sentence was journalized.
Okay, so then it definitely was after the case was disposed of?
Right.
Okay. So how could it be deemed denied if the case was already disposed of? Because the court would have no jurisdiction.
Well,
I'm just trying to understand, I'm sorry.
no, I understand. So, I mean, anybody can file a request to withdraw plea after a case is closed. And so from our position, if the motion is pending, it's just, there's no ruling, then the case law supports that pending motions that aren't ruled upon are deemed denied.
Before final disposition, that's what the case law says, right? So I guess I'm getting at, yes, anybody can file the motion withdrawal, and the court has to rule on it, but that's just almost like, it is like a separate proceeding, right?
It would be a separate proceeding, and I think the point of our argument is that there was no hearing on it. And even after it was remanded, there was still no hearing on it. There should have been a hearing on the motion. And so because there wasn't a hearing on the motion,
There was no subsequent appeal after remand to appeal the court's order denying the motion withdrawing plea, was that?
there wasn't any additional briefing outside of our reply brief, but again, the argument that we're making is that there was no hearing, and that's exactly what happened on the remand. There was still no hearing on that motion to withdraw the plea. So I still believe that it was improper to not grant a motion without a hearing.
6 seconds.
That's it, unless anyone has any other questions.
All right, thank you both for your
Thank you.
arguments here today. The court will take the matter under advisement, issue a decision in due course. We'll make sure that the clerk of courts sends you a copy of the court's decision on the day of its release, and you may also check the Supreme Court of Ohio's website where the opinions are posted. But again, thank you both for your arguments today.
Thank you, Your Honor.